Good afternoon, everyone. I hope you can hear me. Welcome to this seminar on the London Trocadero Insurance Commission decision, where we will be reflecting on the judgment at first instance after the recent compromise of the intended appeal and deciding or considering which aspects of the decision we think were perhaps wrongly decided. I'm absolutely thrilled to be doing this seminar alongside Rudi Ramdarshan, a partner at Ronald Fletcher Baker. Rudi will be very well known indeed to a lot of you. He's an extremely versatile litigator who specialises in commercial and property litigation. He was also the lead partner in the London Trocadero case and was invaluable, certainly from my perspective, in helping to formulate and deploy arguments at trial.
Thank you, Nick. I was indeed one of the lead partners, along with Victoria Huxley, at the firm, working as well with Ni Ama-Olenu, one of our associates on this case. Nick Trompeter KC obviously needs no introduction. He's described by the directories as an outstanding silk who's incredibly intelligent, highly responsive, and someone who you want in your corner. We were definitely pleased to have Nick in our corner, both in the High Court and in the preparation for the Court of Appeal. So, as you probably heard, well, this case settled just days before the Court of Appeal on confidential terms. Obviously, that's a positive thing, you know. I can finally go back to Picturehouse Central, and it's a great cinema. Unfortunately, it leaves the legal position on this, wider industry issues in a state of uncertainty, which prompted Nick and I to pull together this talk to explore some of the arguments that would have been raised.
Now, before Rudi goes on to set out some of the context in which the arguments came to be developed, what I propose to do is just to flag at this stage the three main points we're going to cover over the course of the seminar. The first is the question of construction of the lease terms, and in particular the meaning of the word premium. The second point is going to deal with the question of implication of terms, and in particular something called the Haven Ridge implied term. And then thirdly, we're going to touch on the scope of the law of restitution and the tenant's claim for restitution on the ground of what is known as failure of basis.
Thank you, Nick. And so to understand the core of this dispute, we have to look at how commercial landlords manage insurance. The landlord's managing agent, Criterion Capital Limited, arranged a block policy for a massive property portfolio worth over £4 billion. The block policy includes various categories of insurance, such as building insurance, property owners' liability insurance, terrorism insurance, and the like. Each insurance year, the landlord's agent engaged the services of an insurance broker to help with the process of negotiating and securing insurance for the portfolio. Because of the size of the portfolio and its associated risks, no singular insurer would take on the entire risk. Rather, there would be a block policy with a syndicate of insurers, each of whom accepted a percentage of the overall risk. The lead insurer took the greatest portion of risk, and the following insurers took lower percentages. So it's in this context that there comes about certain types of commission. The judge described three types of commission against the background that, as he recorded at paragraph 37, insurance brokers need to be rewarded for performing their services. In addition to any fee payable by the insurance broker, by the insurer to the broker, brokers might be entitled to obtain commission from the insurers. So what were those three types of commission? So firstly, we had policy commission. That's described as a percentage of the premium charged by the insurer, designed to compensate the broker for their costs in sourcing the client, collating and presenting information to the insurer about the underlying risk and dealing with negotiations, that kind of thing. There was also a work transfer payment in return for certain work that the insurer would otherwise have to do. For example, issuing policy documentation and providing data management and information, that kind of thing. And finally, you had an overrider commission, which is an insurer might pay to the broker in certain agreed volumes if they introduce certain agreed volumes of business in a particular year. It was recognized that brokers did not always retain their commissions and were free to share it. High broker commissions offered a significant benefit to certain portfolio landlords without extra cost to the insurer.
And it's here that we get to see the birth of what the judge described as landlord's commission. So over the years, a practice developed whereby insurance brokers would share their policy commission. So that's the first type of commission that Rudi has described with others. And in the judgment, the judge used the expression landlord's commission to describe the part of the broker's commission that was shared in this way. But importantly, the judge recognised that the landlord or the landlord's agent had no contractual right against either the lead or the follow insurers to be paid a landlord's commission for any of the insurance years in question. Now, all of this then feeds into the judge's analysis of what he understood a premium to comprise as a matter of fact. So he said, and I quote from the judgment, "In all of the relevant insurance years, the premium that the insurers would charge for insurance at the Trocadero represented the sum of the following items." And he listed 3 items. Number 1 was an amount required to fund anticipated claims. So that's a sum that required the insurer to assess the likelihood of claims, frequency of claims, likely cost, and also to build in a profit element. So that's the first bit of premium. Then the second bit was the amount the insurer needed to pay its own expenses other than claims associated with running its insurance business, so cost of employees and such like. And then thirdly, the third aspect of the premium is an amount to cover commissions that the insurer was obliged to pay. The first and second of those 3 items were what the judge referred to, rightly I think, as the net premium. The sum of all 3 items was the gross premium. And critically, I think, as to the third ingredient, the commission that the insurer paid to the broker remained in the nature of a commission, even if it was shared by the broker with the landlord. The judge said in his judgment, and I quote, "A typical landlord and a typical tenant would expect the term premium to include parts of that premium which were used to fund commissions paid to brokers. They would not expect that meaning to change simply because a broker chose to share its commission with another." The other point just to flag at this stage is that the gross premium, so the 3 items I've mentioned, attracts IPT. And the landlord is then liable to pay the gross premium plus the IPT, which is a type of tax, to the insurer.
So what was the industry's understanding on the insurance premium in 1994? So you can find this at paragraph 52 of the judgment. The judge was quite critical, saying that neither side adduced factual evidence as to the understanding between landlords and tenants of the term premium in covenants relating to the payment of an insurance rent in 1994. In hindsight, Nick, perhaps, we could have sourced drafting precedents with accompanying notes, but instead, both parties relied on their experts. With the judgment recording that Mr. Finnegan and Mr. Purvis were agreed at a high level that in 1994, a typical landlord and a typical tenant would expect an insurance premium to include a commission that it had to pay. Now, there was some form of market regulation. There was market norms. It wasn't the Wild West. The market had an element of self-regulation. The payment was for the broker's commission, which they shared. So insurers faced a reputational risk if they allowed those commissions to be too high. And you can see this in paragraph 118. Also, the judge made a comment about market norms for commissions. Critical again, he said neither expert broke down their conclusions on the normal level of commissions between the various insurance years, but doing the best he could, he's concluded that the normal total commission for the policies was 33.75, which was the halfway between Mr. Finnegan's figure of 30% and Mr. Purvis's figure of 37.5%. So make an allowance, as he did, of 5% for off the gross premium. He concluded that the normal landlord's commission for the relevant years was 28.75%.
And just to add to that factual finding, that it was perfectly, quote unquote, normal for a landlord to retain commission at that level over the insurance years. The judge also found, as a fact, that the pricing of the premium in this case for all of the relevant insurance years was arm's length, in the sense that it was a market premium taking into account the amount of commission that was payable. The judge made no finding of secrecy by the landlord. He also found, as a fact, that the landlord's agent had to perform a good deal of work to secure the relevant block policy, albeit he did find that the landlord's commission did not represent an award for that work. Now, with all those factual findings in mind, we can perhaps then move on to the first of the three points that we were keen to discuss today. The first being the question of construction, which was really very much at the heart of this case. And I thought it might be helpful if Hannah may be able to just pull up on the screen the actual wording of the lease, so that everyone listening can actually see what the particular provision had to say. So you should see that just now. So you will see that under this provision, the tenant had covenanted to pay to the landlord. And if you look at little a, you'll see it's a proportionate part of a total sum. And then if you cast your eye past the words in brackets, then you'll see that the proportionate part of the total sum is equivalent to the amount from time to time assessed by the superior landlord or by the superior landlord's insurers as being payable by the superior landlord by way of premium for keeping the centre insured. And it's those words being payable by way of premium that were featured so heavily in the case. And just before I hand over to Rudi, you will have seen peppered throughout this provision reference to a superior landlord in contradistinction to the landlord. And that's because at the time this lease was granted in 1994, there was a head lease which was vested in a different entity, the superior landlord, who actually had responsibility for placing the relevant insurance. Hannah, you can take down the slide, thank you, and Rudi, I'll pass over to you.
Yeah. Thank you, Nick. So let's break this down. So at trial, the tenant did not seek to argue that the concept of premium for the relevant clause referred to the net premium. If nothing else, this was because the tenant accepted that the premium ought to include applicable IPT tax. However, the judge did not accept that premium should then refer to gross premium. He thought it should refer to something else. Rather, the judge said as follows at paragraph 213, to found a payment obligation under the clause, it is not enough that a particular sum answer to the definition of premium. Rather, the sum in question must be an amount payable by way of premium for keeping the centre insured. Read as a whole, the phrase requires also that the sum in question must be, one, payable so as to constitute the real cost to the superior landlord, and must be for keeping the centre insured against the insured risk. So let's look at the word premium. The judge concluded that the landlord's commission fell outside of that definition of premium. We say that's a misconstruction. We say, well, the gross premium is the total monetary payment payable by the insured in return for the insurer's undertaking its obligation. The tenant's own expert at trial, Mr. Finnegan, as well as the landlord's expert, Mr. Purvis, agreed that the premium inherently includes a commission element. If a broker is entitled to a commission of, say, 30% on the reasoning of the judge, then why should it be any different just because they're sharing it? So yeah, that's where were my views when I saw it.
Yeah, I agree with that. I think once you recognise that a broker commission is part of a premium, and a broker commission doesn't stop being a broker commission just because part of it is shared, it's difficult to see why the landlord's commission, part of the broker commission, should fall outside of the meaning of the word premium. So, but as Rudi has described, the judge's first line of reasoning to escape that conclusion was to take the word payable in the relevant clause that you saw on the screen a short while ago, so as to mean constituting a real cost, or elsewhere in the judgment, an actual cost to the landlord. So what you would need to do is to read clause 3.1.6 that you saw as referring not to an amount payable, but an amount representing the real or actual cost incurred by the superior landlord, ... And it struck me when I read the judgment, when it was handed down, that there were two obvious difficulties with that analysis. The first is that the concept of an amount being payable is not the same as a real cost or an actual cost. Something is payable once there is a liability to pay it, regardless if or how the liability is defrayed or recouped. By contrast, a real cost or an actual cost is something which ultimately leaves the paying party out of pocket. And the second difficulty is that elsewhere in the lease, particularly in the service charge provisions, as those listening might well expect, the parties had expressly referred to costs being actually incurred by the landlord. So it might be thought that the draftsperson of the lease had made the conscious decision to frame clause 3.6.1a differently. So that was the first hurdle.
And the second hurdle the judge used was focusing on the word for. He said that the premium had to be for keeping the centre insured. And he concluded that the commission was not for keeping the centre insured, but rather for providing the landlord with an opportunity to profit at the tenant's expense. The tenant accepts, however, that IPT, insurance premium tax, is recoverable under the clause, but IPT is absolutely not paid for keeping the centre insured. It doesn't buy any insurance, it goes straight to the public purse.
Yeah. And it struck me that the word for in the lease simply didn't bear the weight that the judge had ascribed to it. Really, what that word does is simply describe the type of insurance that is required under the particular provision in question. So in clause 3.6.1a, it's insurance for the buildings insurance. And then in a fairly conventional fashion, you have a series of other subclauses where there are different types of insurance that are described there. So insurance for loss of rent, for example. So that's why I think that his reliance on to introduce us as the judge would have in a purpose requirement in clause 3.6.1 was wrong. What the judge did, however, was to justify his interpretation by concluding that the landlord's interpretation produced, as the judge put it, an unreasonable outcome. because it would allow the landlord to inflate the insurance rent. Well, I think there are two things to be said about that. First, the court should be very slow to reject the natural meaning of a provision simply because it appears imprudent for one party to have agreed it. But also, the question of an unreasonable outcome, as the judge saw it, rather depends a little bit on the implied term point, which we're going to come on to in a moment. But actually, so far from the landlord's interpretation being unworkable, it might be thought that the judge's interpretation is unworkable. Because if one measures this by reference to circumstances in 1994, when the lease was entered into, the landlord didn't have primary responsibility for keeping the centre insured. You may remember I drew attention to the existence of a superior landlord. So the superior landlord was the entity responsible for taking out the insurance. And on the judge's analysis, the landlord who didn't have responsibility for taking out insurance and who wouldn't know necessarily about what the superior landlord was doing would have to interrogate the superior landlord's insurance arrangements, ascertain whether they included any kind of landlord's commission, figure out if any of it was rebated, strip it out of the gross premium, and then recalculate IPT on a net basis before making a demand from the tenant.
Which neatly leads us into the judge's fallback position, that the back rooms, if you like. The judge stated obiter that if he was wrong on the construction, he would simply imply a term into the lease. And this is at paragraph 262 of the judgment. This was referred to as the Havenridge implied term, which was to the effect that the landlord was only entitled to demand sums by way of insurance to the extent that such sums were representative of the market rate and as reflects insurance contracts negotiated at arm's length in the ordinary course of business. Nick, do you want to tell us more about Havenridge?
Yeah, so the Havenridge case concerned a lease with very different language. The relevant words in the lease were that the lessee will pay to the lessor on demand all yearly sums as the lessor shall from time to time properly expend or pay to any insurance company. So the case was really concerned with what was meant by proper expenditure. It's also questionable whether Havenridge is even a case about implied terms at all. It's a decision of the Court of Appeal, albeit one where there were only two judges, each of whom gave different reasons. One of the judges, I think it was Lord Justice Peter Gibson, thought that the case could be decided on the express terms of the lease, and the other judge, I think it was Mr. Justice Evans, thought that the case could be decided on express terms or on the basis of an implied term. So Havenridge itself doesn't actually provide, in my view, a very reliable footing for the implication of a term. But ultimately, whether or not a term is to be implied, as everyone listening will know, is a question of necessity, not reasonableness.
Yeah, Nick, the judge appears to have relied to some extent on a 2015 trigger event where the landlord acquired the reversion. So the landlord was both then the superior landlord and the landlord. How does that feed into implication of the Haven?
Yeah, so this needs a little bit of unpacking. They're corresponding with clause 3.1.6 of the lease. There was a fairly conventional sort of provision binding on the landlord, which was an obligation that the landlord had to procure that the superior landlord actually complies with its own obligations, own insurance obligations under the head lease. So that way that the sublease and the head lease also neatly married up. The 1994 sublease also contained a provision that said if the landlord effectively becomes the superior landlord, then all references to the landlord, to the superior landlord in the lease, effectively have to be read as references to the landlord. And what happened in this case is that some years after the lease was granted, that is exactly what happened. The superior landlord and the landlord became one and the same person. And the judge thought that in that situation, there was no difference between a landlord procuring someone from obtaining insurance, from actually doing the very thing itself. Why is that relevant? It's relevant because the trigger event, as the judge put it, occurred after the lease was granted. And in referring to or placing weight on that event as justifying the implication of term, in my respectful view, the judge fell into the trap identified in a number of leading authorities on implication of terms like the M&S case. That is, by fashioning an implied term using hindsight. And so our simple point was that when you look at the landlord's obligation under the lease, which was to procure a third party does something, to imply a Haven Ridge term, as the judge did, would be to contradict the express terms. The relevant provision in the lease obliged the landlord to procure a third party to insure the centre. It didn't oblige the landlord to insure it directly.
And Nick, the judge didn't stop with the orthodox understanding of arm's length. Arm's length morphs into an entirely different beast. He stated that arm's length negotiation connotes an absence of any intention to confer benefit on the landlord at the tenant's expense. Nick, how does that work? For me, that seems to create a fiduciary obligation in the context of a landlord and tenant relationship.
It's not altogether straightforward. So just to unpack this a bit, the judge's implied term, the Haven Ridge implied term, was along the lines that any insurance that the landlord arranged had to be at arm's length, but in the very specific and particular way that Rudi has described. So absent any intention to confer a benefit on the landlord at the tenant's expense. And as Rudi has, I think, rightly pointed out, it's difficult to see how that could possibly work in practice. And it seems almost to put the landlord and tenant into a position of fiduciaries. And it strikes me, if nothing else, it's commercially unworkable, because the entire insurance arrangement is one that fundamentally benefits the landlord at the tenant's expense. Insurance is not there just to benefit the tenant, as all those listening will know. The insurance there is also to protect the landlord's interest, in this case in the Trocadero building, by ensuring that the bricks and mortar are properly insured, and the tenant contributes to the cost of that. And so with that in mind, I would suggest it's impossible to see how you can have an implied term which connotes within it an absence of any intention to confer a benefit on the landlord at the tenant's expense.
And that brings us squarely to the remedy the judge actually granted. So the judge found at paragraph 233 that there was no implied term requiring the landlord to repay the sums in excess of the contractual entitlement. The only remedy, therefore, was in restitution. And the principal unjust factor relied on by the tenant in support of its claim for restitution was a failure of basis. In this respect, at paragraph 330, the judge ultimately concluded that there was a total failure of basis in relation to the payment of the amount corresponding to the landlord's commission, even though the tenant benefited from insurance cover during the years in dispute. Hence, the tenant's claim for a restitutionary remedy succeeded.
Yeah. So, as Rudi has described, the tenant's principal basis for the restitutionary angle was failure of basis. For those listening, the concept of failure of basis is probably something that will be familiar to you. If you go back to a case that's now reasonably old called Fibrosa, it's now pretty clear that the basis, when you talk about failure of basis in unjust enrichment, refers to the performance of the promise. To put it another way, money is paid in the expectation of performance by another party. If there is no such performance, then the inducement or the condition is not fulfilled. And it's this idea of a conditional payment that has been taken forward into the modern law of unjust enrichment. And it's because of that that it becomes so very, very important to identify correctly the performance, or the condition, if you like, upon which the payment depended. And so with that in mind, you can then ask in this case, well, what was the performance that was expected? What was the condition in return for which the payment was made? And there were two possible analyses that we advanced at trial. The first analysis was the one that found attraction with the Court of Appeal the last time this case got there, which was in the context of the COVID rent dispute. And you may remember that the tenant during COVID had stopped paying rent. And one of the arguments that the tenant sought to deploy in the Court of Appeal on that occasion was that there was effectively a failure of the basis upon which the rent was payable. And I submitted in the Court of Appeal on that occasion that that was wrong, because the lease expressly spelt out that all of the rents were in consideration of the demise, and the demise hadn't failed. The demise was still there. And the insurance rent is just as much the rent in this case as the passing rent. And it's difficult to see why, if that reasoning worked in the Court of Appeal the first time round, it ought not to have worked this time round as well. So that was the first argument. The second argument was that the tenant paid insurance rent for the expressly stated purpose in clause 3, i.e. the performance of the landlord's obligation to keep the centre insured.
And there was a demise, and the centre was insured. The block policy was in place. The tenant received the exact physical performance and commercial benefit they paid for. There was no failure of performance, and there was no failure of basis.
Yeah, that's absolutely right. And so, again, those listening will appreciate that for there to be a failure of basis, the failure has to be total. In the arguments that we advanced before the judge, we said the performance hadn't failed, or certainly hadn't failed completely, and just as Rudi has described. So in order to get around that, the judge fell back onto the doctrine of apportionment, which serves to mitigate what would otherwise be a fairly harsh operation of the failure of basis doctrine. Now, apportionment applies where a contract is divisible into separate parts. If a divisible part has wholly failed, and part of the consideration can be attributed to that part, then the portion of money can be recovered.
And the judge apportioned the payments into two parts. There was a part that was contractually due, the net premium, and a part that wasn't due, the commission. And he said that the basis totally fell for the commission part.
And I think that is fundamentally wrong as an approach. Apportionment, properly understood, is only permissible where the performance is divisible, or the condition on which the payment depends. It's not available simply because a monetary payment consists of identifiable financial components. There's an old case called Wincup and Hughes, which serves as an example where someone has contracted to purchase, say, 10 bags of grain, and the seller has delivered 5 bags but hasn't delivered the remainder. because the performance is neatly divisible amongst the 10 bags, there has been a failure of basis in respect of the 5 remaining bags, and therefore you can claim the money back, which is referable to that part of the performance. But it's impossible to see, as I would venture, that something similar could be said about the performance in this case, which is on the analysis that I've sketched out, either the demise, which continues to exist, or the provision of insurance cover, which was actually provided.
So that provides a kind of a whistle-stop tour of what we would have argued on some of the key points. There were other points, but we, obviously time being what it is, we can't really go into all of those. But I mean, overall, we were both really looking forward to the call.
We were,
and for me, and I've been consistent throughout that I felt that the key point was construction of the word premium. If a broker's commission is part of the premium, if it's okay to pay the broker 30%, then why is it not okay if the broker chooses to pass that on to someone else? That was what I felt was the key part.
I completely agree with that. And I mean, just to add, the very fact that IPT is part of the commission, as Rudi has described earlier, makes it very difficult to see why the landlord's commission, which is shared out of another part of the premium, shouldn't also be on proper construction of the lease, part and parcel of that very same concept. And ultimately, we got permission to appeal on all of the grounds. The judge at first instance gave us permission, I think, on 5.5 grounds, and then Lord Justice Lewison gave us permission when we renewed our applications for permission to appeal on, I think, 2.5 remaining grounds. So as Rudi said, we were both very excited about the case. We were looking forward to the fight. Unfortunately, it means that the matter will have to be decided another day. But I think where the law is, I don't think that the decision at first instance is the end of the story. Obviously, it turns on the particular wording of the lease in question. But if anyone has got the appetite, there's definitely mileage for fighting on these points. I don't think the law is settled one way or the other. But a few minutes to 1 o'clock. Thank you all very much for listening. Rudi and I are very happy to take questions. You can email us directly if you like, or you can also email the marketing team at Selborne Chambers. And on that note, wish you a very good afternoon.
Thank you.
Thank you.